circle back where we started. This was an article just this week in the Pittsburgh Post-Gazette talking about the same Steeler physician that got me interested in this litigation. And it says the program that they had started about concussions in Pittsburgh dated back to the 1990 when Chuck Noll was the head coach of the Steelers, and he wanted Dr. Maroon to provide him with a more objective and scientific method than his gut feeling for determining how long a player should be held out of games after suffering a concussion. Go ahead. Flip through those. And I think the most important thing that we can all leave here with is, again, to remember that this isn't about the lawyers, this is about you guys. And I think Bruce said it best yesterday, that we all need to work together. And I think it's up to all of you to speak to your fellow players that you play the game with and help them out and get them involved. Have them come to Rich and I. Have them come to anybody who can help them out. Because those that have these problems, one thing that I've noticed is they can't help themselves. They need that help from you guys. And the three things that ultimately need done out of this is really simple. Number one, educate the future generation that play the game. Number two, make sure that there is medical care for all of you retirees. And lastly but not least, to make sure that you do deserve the compensation for the injuries that you suffer. And with that, I'll turn it over.
Thank you, Jason. We really appreciate that. I'd like to now introduce Richard Lewis with the Hausfeld Group, and that's another fine organization that's really helping retired players.
Yeah, thank you, Dave. Thanks, Jason. Thank you for inviting us to this conference. It's really an incredible collection of information that's being provided. The medical lectures this morning were very informative, and when I was sitting there watching it, I wished that the judges were here. The judges in our country have incredible power over deciding your cases and a lot of things that happen in people's lives, and they get a very sterilized, narrow view of what's really happening with these problems. You know, there's certain rules that we have in court, and it's not easy to always get the information to them. I was involved in a litigation involving breast cancer and a drug, and we started having science days all around the country for every judge who got assigned what was called a hormone therapy breast cancer case, where we just came in and presented our view of the science, and the other side got to present their view of the science, and we didn't have to beat each other or argue with each other. We just each got a chance to try to educate the judge in advance of hearing the evidence, legal rulings about what was really going on. And if we can get people like the doctors that were here this morning and folks from Dr. Amon's clinic to come in and talk to the judges that will decide your cases early on, I think it would help a lot. Jason brought out some great points, some very fundamental issues driving the litigation. We'll all take questions about the cases. Next slide, please. So most of the brain injury cases today are in the federal legal system. There's two parts to our civil legal system, the federal and the state. And most of the things I'm going to say are about the federal, because that's where most of the cases are today. That might change in the future, but right now most of them are there. And the federal courts have a system of consolidating cases that are similar. So the federal courts have decided that all these brain injury cases belong in the same court for what's called pretrial litigation. So before you actually have your trial with a jury where they decide your case, a lot of other stuff happens in advance. And so all these cases have been sent to Philadelphia, to the federal court, to a judge named Anita Brody. Next slide. And that's a picture of Judge Brody. She has a reputation for being a fair and careful judge. And those are two pretty good adjectives, especially these days. I think a lot of judges wouldn't meet that criteria. But we are optimistic that she'll give us a fair hearing on everything, but we haven't begun in substance to argue before her. The first hearing is April 25th. We'll get started. Next slide, please. This is simply the caption. All the cases are now going to be sent to Philadelphia and consolidated for pretrial purposes. And they'll all have that name. And there are about 44 lawsuits there today, but many of those lawsuits have multiple players on them. So there are about 1,200 former NFL players who have a brain injury lawsuit in the federal court. And what I'm going to talk about in a minute is two kinds of claims in that court: personal injury and medical monitoring. Those are two different things. I'm going to spend really little time on the science because it was covered by the real scientists this morning, but I want to just make a couple observations as a lawyer about some scientific issues that are going to come up. One is this idea that some of us, who don't know a lot about this, as you guys do, thought that concussions were sort of head-on-head collisions, acute, once-in-a-career events where someone gets taken off the field in a stretcher. And we've learned pretty quickly from the scientists that that's not really what this is about. It's about the rotation of the brain inside the skull, and it's about many subconcussive impacts or hits during the course of a game or a practice or a career. It's not about this one acute injury. So one of the problems is subconcussive hits, dozens, hundreds, thousands, are not in your medical records. They weren't viewed as medical events at the time. And lawyers prove personal injury cases, traditionally, conventionally, medical records are really important. So that's going to be a big challenge for us to be able to accurately characterize all those hits that's part of the causal chain of what have medical records or a history of cigarette smoking that can be documented in black and white. So it's going to take a lot of work to do that. Next slide, please. As the doctor said this morning, there's now sufficient evidence that brain injury is caused by playing football, and it comes from different kinds of scientific studies. It comes from case studies. When a smart doctor sees a player who's hurt and writes it up. Dr. Amon's work is he's working with living players, trying to diagnose them and treat them in the present tense to help improve the quality of their life. Some of the traditional medicine about brain injury is looking at autopsies. And that's very important, but obviously that alone is not going to get us very far for helping people who are alive who need help now. So the autopsy studies are a part of the science that we need, but only a part. Neuropsychological studies, testing your reaction time, testing your memory, that's going to be a very important part of this case because we can diagnose players without autopsies, with living, non-invasive procedures to get accurate information. Brain imaging studies are also part of that mix of science that we're going to be using in court. The idea that it's not a single concussion is going to be critical to this litigation and really expands the universe of players who are affected. Guys who had terrible luck who got carried off on a stretcher. That's not what this litigation is going to be about. It's not going to be limited to that. Next slide, please. These are just some of the examples of the studies. This is the conclusion in the AMEN study, and I want you to look at that word suggest. The results of this study suggest that playing professional football is associated with a significantly higher risk of brain damage. These are scientific terms. Suggest, associated. Scientists are very reluctant to use the word cause. Very reluctant. And we have that burden in court to prove cause. But cause in a court is 51% likelihood, that it's more likely than not that your history in football caused injury. That's what we have to prove. But sometimes it's hard to get the scientist to speak either English or to speak a language that the court understands. So we have to take the scientific language, the legal language, and bring it to bear to win these cases. Here's a conclusion from the autopsy studies done by the folks at Boston University. The results of a study suggest that, I'm sorry, next slide. There is overwhelming evidence, the second sentence, that the condition, that CTE, is a result of repeated sublethal brain trauma. So that's helpful. That's a more conclusive statement. But of course, those are the autopsy studies. So these are some of the challenges we're going to face making the science work for us in this litigation. Next slide. Jason talked about the liability, the question of what did the NFL or what did Riddell know? Because in addition to proving cause, we have to prove fault. We have to prove this isn't just bad luck. The NFL is going to say, well, we didn't know either. Why are you blaming us? So we're going to take a look at what they did know. Jason showed some slides going back to 1950. That's very important because we want to be able to cover all of the players, not just those who have played in the last 5 or 10 years when the studies, more sophisticated studies have come out. And we believe there will be evidence reaching back to the 50s to show this, if not earlier. The analogy to the boxing literature is very important. And that literature has been around since the 1920s. In the 1970s and 80s, studies were starting to be done on football players. The University of Virginia did a big study. The results of that study were published in the Wall Street Journal. These are newspapers that NFL executives could read without being doctors, without being scientists. So we think we'll have good reason to show that they were on notice. There was a red flag. They should have known better. They shouldn't have put their head in the sand. These are some of the things we're going to have to prove. Next slide, please. I guess the last legal point I really want to make is a very important one to me, which is that people understand the difference between personal injury claims and this kind of strange term that I'm going to talk about called medical monitoring. So let's start with personal injury. Each of you that have a claim or are thinking about bringing a claim for yourself because you have a brain injury, that's a personal injury claim, and it's brought by you as an individual. It is your individual case, and you will be entitled to an individual hearing and a day in court at the end of the day. It is not a class action, and it can't be a class action. Our legal system won't allow the grouping of personal injury claims. It's an individual case seeking individual damages based on your individual proof. And in the end, there will be an award of compensation that's tied to what in that case. So even though you're all put together in Philadelphia right now, and people might call it a mass tort or a consolidated action, it is your case, and it's only put together for limited purposes. At the end of the day, your own case will have to stand on its own feet, and you will win or lose your own case. It cannot be a class action, okay? There's a second kind of claim called medical monitoring to pay for medical tests than the rest of us, and has a special needs testing to identify that it can be administered to these players and that it'll help them, and it'll help their doctors take care of them. And I think that's a very important claim in addition to personal injury. because a lot of people who haven't filed lawsuits probably need that testing and might not be aware of it. That type of a claim can be brought on a class action basis. The other side, the NFL, will argue that it can't be. But we will argue that this problem is common. It's the same for all of these guys, whether they played in the AFL or the NFL, whether they played in the 70s or the 90s, whether they played on the line or in the backfield. They're all at increased risk. They all need these tests, and they need it in part because the NFL was negligent or careless in the way they dealt with this issue. So there's overlap between the individual personal injury cases and the medical monitoring. There's legal overlap, but they're also very different. The medical monitoring claim, which does these as we represent the players. And when I say we, that's Jason's firm, that's my colleague Jim Mitchell, who many of you know, that's me, and that's a dozen or 2 dozen other lawyers in the country who are working on this. We have to work together. Rivalries between the lawyers will hurt us. It'll hurt us in front of the judge, and the NFL will take advantage of it. So we are working, trying to discipline ourselves, trying to suggest to people who are being a little too aggressive about getting clients that that's not helping anybody if they're doing it by one-upmanship over other lawyers. None of that is going to be good, and some of it has happened, and we're trying to control that. Last slide. So on the legal side, our firm and my partner Mike Hausfeld, who some of you know, are also involved in the Eller case and the Dreyer case. Those are different cases. You know, Eller is about the strike and about union rights and about the issues between the union and the retirees. Dreyer is about rights to your image. Concussions is about what we've been talking about today. So technically, and there's a lot of differences between those cases. However, they're all about retirees and about getting justice for you guys for what's happened in the past and to give you some assistance and compensation for the future. So that's everything I have, and I'll just sit down, and if we have any time for questions, that'd be great. If not, we'll talk to you at lunch.
Thank you, Richard. We really appreciate that. And you and Michael Hausfeld, you're doing a lot for retired players, and we certainly appreciate that a lot. So now the floor is open to you. Who has any questions for this panel of distinguished lawyers? I'll tell you what, would it be possible to go to the microphone so we can, yeah. If anyone asking a question, if they would please use a microphone so that we can all hear, please.
Test. Oh, there we go. I felt that in at least one of the suits that I read, that one of the claims was the NFL was a monopoly, and I'd just like more clarification on, I mean, is this antitrust? Like I say, monopoly. Could you explain why that was part of whichever lawsuit was filed?
Sure, that would be part of the first couple lawsuits we filed, and we allege that in every one of our lawsuits. They were actually legally determined to be a monopoly when there was the litigation involving the NFL and the USFL. I don't know if you all remember the USFL, but that was the league that ended because the NFL was the stronger power. They monopolized football. And the reason that that argument is made in the case is really simple. Go back to the Orlando Brown case. The duty was owed by the ref, not just Brown, but to any person present in that stadium. The same idea applies here. The NFL duty to disclose the long-term cognitive problems of concussion not only affects, pick any guy in this room, but any doctor, any league of football and just sports in general. And that's where the argument made its origin.
A question. One of the issues that we always have in all litigation, of course, is the statute of limitations, and often the statute of limitations is told because somebody does not have knowledge. Now, in this instance, there has been a massive amount of media attention. There's hardly a week that goes by where we don't read something about this type of litigation. We don't hear something on the radio. We don't see something on television. Now, at some point, if you gentlemen are successful in your claim and resolving it, there may be a mass of another group of players wanting to participate. Are they going to be at a great disadvantage because of the knowledge factor?
Sure. I
guess in essence, if somebody's interested, they probably should join up now.
Well, that's the bottom line answer, and I can't say anything to improve on that. But just for a little background, the statute of limitations is basically a legal term for you should have done something reasonably close in time to when you knew or should have known. And I would suggest that there's two parts to that. One is what information was out there that playing football can cause brain injury and that a reasonable person would have been aware of. But I would also argue, and there's no answer yet from a court on this, that you have to have a diagnosis, that regular people, including football players, aren't in the business of figuring out what causes brain injury. And until you have a doctor who's diagnosed you and laid that out for you, you really don't know. That's just an argument. The best legal advice that Ron is suggesting or that Jason and I could give is that if you have this concern, you should talk to a lawyer as soon as possible to get on file. Some lawyers have suggested that the NFL's announcement in June of 2010 would be the time that the clock starts to run. And in most states, you would have 2 years from whenever that date is that a court determines the clock starts to run. So I think Jason and I would suggest that perhaps get your case filed by June 2012 to be safe under that thinking. But we can't guarantee in advance what the court will rule. So the best advice is absolutely as soon as possible to get on file. But for people who think about this a few years from now or know younger players who don't get diagnosed until 2013, 2014, whatever, we should not be telling them to forget it. They should be talking to a lawyer at that time also to pursue it.
Gentlemen, Bruce Laird, I just have a couple questions for the entire panel. Of 1,200, I would assume, retired players, some vested, some not vested, that have signed on with the various law firms, do you know how many are pre-1993 players?
I don't have those numbers. I can just give you rough estimates from our own client base, but
okay.
It's not, I don't think it's been, we haven't figured that out yet.
Oh, okay. And the other thing, as the league is developed, in my years in the National Football League from 72 to 83, we did have orthopedic groups were part of the team physicians. In other words, your team orthopod, your team eye doctor, so on and so forth. Now the orthopods pay to play. Is he a part of anything that you bring up that, in other words, the team doctors, the orthopedic team doctor for the Baltimore Ravens per se, pays a PSL. In other words, they pay a license to the team so they can be the doctors. Are you guys aware of that?
I am. Do you know when that practice began?
That, I don't know. I know in my career with Baltimore, which was 10 years, I do not think, I think our team orthopod only got the so-called kudos for being, Dr. Ed McDonald, team doctor. But I do know that now, I mean, it's a PSL. I don't know one thing for a lot of times, and you always pay to play.
Is that a team or a league thing, Bruce?
I think it's a team thing, and once it's a team thing, it's a league thing. Once you talk to, if you talk to owners, if you have relationship with owners, they talk about their partners. They talk about their business partners. The National Football League is about 32 business partners. They compete on the field, but only on the losses. Everything else, as you know, the economics of the NFL is shared. So it's a great socialist system. I'm trying to get that in my company, by the way. And I'm almost seeing with my other thing.
Bruce, that first question you raised, it's a really difficult one because nobody has sued the team because we don't want to be told that we can only be in the comp system.
Right.
So it hasn't been tested yet in this case, but in the initial stages, we're trying to focus on league conduct and actually avoid team conduct. It's one of these legal niceties that doesn't really fit the real world, but we have to try and walk that line.
And I'll share something else with you. A lot of other players probably could in this room. In my career in the National Football League, like I said, there were team doctors, orthopods, team medicine, eye doctors, all that. But nowhere was there a team guy. And I understand because of what has happened with what we have, not so much the litigation. I mean, the litigation started, obviously. But what has happened, now the team has a team neuro. Do you know when that started?
With the Mild Traumatic Brain Injury Committee, it was a league mandate.
Okay, so that was it, because that's when it gets back to you gentlemen stating to us, now whether we would do that or not, but I think if my loved ones or significant others or your parents were to sit down before you signed your contract and told you of these things that they're very, very possible, and you know, that your thing, Rick, that 3 strikes are out in 1945 was unbelievable to me.
You would have played baseball.
Well, I would have tried. I couldn't hit. I mean, you know, but else. But thank you, fellas.
Bruce,
I appreciate
one point on the conclusions of the University of Virginia football study in the early 80s, that there are valid neuroassessments that can pick up football players. Mm-hmm. And why is it that they, you know, this is like a paper and pencil test, maybe an hour and a half. Why weren't they given to you guys in the 80s if it says in the New York Times that there's tests to be used to pick this up?
Yeah, and that's the point, because, I mean, and every one of us, and I'm talking about pre-93 players more because, you know, that's where I come from, but in that regard, there was never any conversations about that. I was multiple concussed. I sat out the 78 season because my wife took me to the neurologist. My wife took me there, not my team doctor. She said, "You just have I want you to go." He sat me out for 2 weeks. I hit this guy for 10 years, twice. I mean, so all those other things about, we used to call them, and Cooch, you probably, we used to call them snappers. The ammonium things. I used to have a guy that carried them around in his belt because I needed my snappers. Call him. I said, "Kasich, snapper." And it's done. You hit this guy enough time, hit people. And I wonder if, you know, about that, and you put your case out, if you get some people to think that's what we lived on.
There's one last thing. I think.
Yeah, I know it made me feel good at the time.
One last thing, and not to pat ourselves on the back, but you know, our 2 firms here represent a large number of these people, and if I were to guesstimate on the number of people that we represent, I would say that probably a good 75% of them are pre-93 folks, at least.
Okay, and thank you.
Isaiah Robinson, Dallas, Texas. One of the things that we've heard a lot about is an attorney by the name of Tom Girardi. Can you all explain, you know, your affiliation and
Sure.
Both law firms, as far as what does Tom Girardi mean to this lawsuit?
Sure. I guess I should start because I brought Tom Girardi onto my team of lawyers that I was talking about earlier. And Tom is out of California for 40 years and was the head lawyer filed. And now he sits on the panel, which I don't think is official yet, right, Rich? Not yet. But he will sit on the executive panel along with Rich and his partner from Hausfeld.
Yeah, I would just say, I mean, we all saw the Aaron Brockovich movie. Tom Girardi's a great lawyer, but it's not really about, in my opinion, there are a lot of good lawyers in this litigation, and we're all fortunate because it's going to take a lot of us to fight the hundreds of lawyers that the other side is going to throw at us. But we have cases with Tom. Tom has a affiliation with Jason on his case that's much more direct than, but it's really about the lawyers getting together and doing their best work to fight. You know, it's a little bit of David and Goliath here.
My last question is, how can, say we, I mean some of the chapter presidents, the NFLPA, get some of the information here that we can take on to our other members and other chapters? Because anything that I've ever come across while I've been involved, brain concussion and the NFLPA. And so I think that it's all about educating the player, and the PowerPoints from each one of you.
Let me answer that question. Are you familiar?
I'll tell you what.
Yeah.
You'll be able to get this.
Okay. I get them every day. Yes, I do.
And I are interested in talking to players in Dallas or Los Angeles or anywhere else. And I don't know how busy the doctor is, but if you have a group of people in your hometown and you think one of these meetings would be helpful, we would work with you to.
Hey,
Isaiah, if I could just add it as a contact, I would be happy to. And everything is put up on the blogs, lawsuit to the one again. Yeah, thank you.
When you, and I'm just kind of curious, you have a lawsuit. Well, if the game continues to be played, there's going to eliminate the concussion. So we have the laws for a monetary compensation to the people that may have experienced concussions now. But the final analysis is, are we trying to, will this help the disability plan in the future, saying, hey, these are part of a game, so you have a responsibility, unless you just quit the game?
I'm confused, but is the question, will this help the disability?
What is the response from the owners when they come there and they say, well, what do you want us to do? Concussions are part of the game. We're going to get them, no matter how safe you make it. The owners say, we can change it.
That's CBA, it has, you know.
And correct me if I'm...
Hope is that the owners are going to stick to make them, take responsibility, and to players like you are taking care of. And whether or not they do that, Jim Irsay is a close friend of mine, and he's alluded to the fact that because of all these things that are happening, what could possibly happen in the future would be a waiver that the players would have to see. But listen, there's going up in the locker rooms right now that says play at your own risk. So I think down the future, there's still going to be guys, big time money, but if you, at the end of your career, and you can't come back on them, so that's probably what's going to happen. That wasn't my point. One question that I had is, I know that you guys have sent out information about adding our wives to the lawsuit. What is your strategy there?
In our cases, we are adding spouses join, bringing what in legal terms is called a loss of a player who has a brain injury, full person who was your husband. And that's what that claim is about. And I think that for anybody who has a provable brain injury, it's reasonable to think that the spouse also has a claim.
This question on when did they start reading my rookie year? We had one covered back then.
Great deal. What we're looking at from the foundation that is, you guys do the right thing as we come up with a comprehensive plan, both prevent injury acutely and treat the older injuries that have already happened. So if there's a remedy, as you know, they're a lot more likely to make a reasonable settlement if the number becomes some finite amount that they know they can do. This is a remedy, and then we go on and do that as we've done in congressional law a number of times. If there's a remedy, it's always easier to make a deal.
Yeah, I think from a legal perspective, so there's no lack of remedies. We just have to go and get the remedies.
Yes. You mentioned that. How much are our medical records going to come into play? Also, if there be something in our records, how does that come into play? And the next was this: how much of our films and involve that, and does that come into play, and how do medical records should have done, or is there some standard for what should have been kept? Since you're talking about information, how much does that come into play?
Sure.
Rich?
Yes, Jason, go ahead.
Personally, I think the films are more important than the records, because I always love to ask this question to you guys. The NFL has injury reports. When is the first time that a concussion was listed on an injury report? That's the same answer I get every time. The response was recently would be the first time. So your medical records are not.
There are none.
Going to say concussion.
Every guy in here can tell you a play that he had. I don't care how bad our memories are. Every guy in here can tell you a play that in a game he got zoned. Last after 1982, Brian Goldberg, 6'7", 315 pounds, hit me in the side of the head. I was knocked out on my feet. Every guy in here can tell you some game he got bombed. Period. It speaks for itself.
Yeah, just on the medical records, I think like I said, the conventional way to prove personal injuries involves the use of medical records. And your medical records, whether you like it or not, if you bring a personal injury claim, every medical record that can be found on the face of the earth, we have to the other side. So that they're going to be in the case. But to provide the relevant, there's nothing stopping us from, so the answer to all of your question, to establish, the relevant history of impacts. Although I think that we may have people arguing, and we may have experts testifying, what NFL player didn't have a history of subconcussive impacts. I'm not sure how somebody would argue that all you guys didn't have that kind of history. But the short answer to your question is that all that stuff's going to be involved in the case.
Richard, you used the term loss of consortium, and amongst the general public, there's a belief that that's limited to sexual activity with a spouse, but it's not a necessary component, and it's only sometimes a component. I mean, the real definition of loss of consortium is loss of society and comfort. And so for anybody's spouse who's considering participating, that's exactly what Richard, he didn't use those words, society and comfort, but he went on to say that it's the really loss of companionship. Oh, one thing you asked, when did the doctors start paying to become the orthopedics? It started with the Jacksonville and the Carolina franchises. In fact, there was a major article, the first two franchises that realized the greatest boon that doctors have to their business, that once they're identified as the team physician, the general public thinks that the teams choose only the finest doctors in their relative fields, and the practices of doctors literally explode. I'm aware of one that went from, exploded within 2 years 7 times after he was named the team physician.
So do we have time for a 30-second anecdote here? So my great uncle had the balloon concession at War Memorial Stadium where the Buffalo Bills played in the 1960s. That was his job. He sold balloons. And when the Bills, Ralph Wilson, the owner, they took over everything connected with football. In the old stadium, you had people selling balloons, you had people making hot dogs, you had people doing parking. In the new stadium, all that was gone. It was all Buffalo Bill property. And I think it's really the predecessor to what happened with the doctors. You know, the lead, everything from balloons to medical care.
Are there any more questions? Really like to thank this distinguished panel for being here. I'd like to, without their support, we wouldn't be here. So I certainly thank them, and if you haven't signed up for a concussion lawsuit and you have a concussion, you need to consider joining. This afternoon, we're going to have a lunch break now. The lunch break is going to be from now until 1:45. And then at 1:45, I really encourage everyone to be here. We're going to have disability attorney John Hogan, who does nothing but practice disability law. And what John's going to do is, John's going to give us an overview of the disability debacle and the pensions. And in my opinion, we wouldn't be here if we had a legitimate disability plan and a livable pension. But we don't. And unfortunately, the only way we're going to get a restitution, lawsuits, the court of public, and help from people in Congress. So the ball's moving along, and appreciate your attention. We'll now break for lunch, and please be here around 1:45 because John is going to give you some very valuable information. Thank you very much.
Richard, yes. Thank you.